Yes, Mr.
That five, that 502 which I mentioned yesterday, so about that.
I'm sorry.
Arbitration matter.
Arbitration
The committee
matter.
is tenure has been extended by one more month. I think by middle of November, so.
So the arbitration matter, what we can do is we will keep on maybe sometime middle of November. Would you like to for us to take it? So presently we can just keep it because you are still the process is still continuing. Then, Mr. Banerjee, we can keep arbitration. Who are the other lawyers appearing in the arbitration matter? So, if we keep it, let the government is sorting it out, then nothing like it. Right.
The next thing at least for
Certainly. You can just say that on the request of the Learned Attorney General for India, Star Venkatramani, Learned Attorney General for India, states that a consultative process is being carried out by the government on the proposed amendments to the Arbitration and Conciliation Act 1996. Full stop. Hence, it has been submitted that the reference to the Constitution bench may be taken up preferably by the middle of November, at which point of time there would be clarity on the law. Full stop. List on Kardor. And incidentally, I don't know if the arbitration, especially all of you are specialized lawyers, the curative petition in the on the issue as to whether the an unstamped agreement, registration stamping, that may be taken up. I'll just see how early we can list it, possibly next week or something. It of course has 5 judges, the curative, because we would like the assistance, irrespective of whether you are appearing in that matter or not. We would like the assistance of the bar. So in fact, can even those who would like to appear may contact the courtmaster. So he'll give you the date when it is coming. But we like the assistance because that's something which is really a matter of
NN Global.
NN Global.
If you can't go to the committee.
No. Committee, as Brother Nasma said, because various other laws are involved, the Stamp Act, etc.
Right.
So we'll hear the review and then settle the law. I mean, if the judgment is right, of course it's right. If we feel that there's some point for consideration, we may have to refer to 7 then. So the earlier judgment was 7.
I'll look at it.
One housekeeping request in 9.502, I have filed an intervening application. I am not able to access the records because they say till this application is allowed, you can't see the records which are there.
They don't soft copy. They do. All right.
If my lord could grant,
they will give you a soft copy. Don't worry.
The office of Attorney General is more open.
Yes.
I've shared a brief note on this matter.
Yes, you got the note. Something will be aside. So. Mr. Note.
Yeah.
Mr. Attorney, if you would like to take a seat for a minute,
Yes,
you can
yes.
sit for a minute because you're just setting up your note on the screens. किसी बंद है क्या आज? किसी बंद? Yes, Mr.
You'll also straight away go to paragraph 5 of this one. I had more than one set of discussions with the officers. It transpires that the two notifications in question, which are referred to in the referral order. Yeah. So may I read paragraph 5 onward. The application of so-and-so enables a person holding a license for light motor vehicle to drive a transport vehicle on the strength of that license without a separate transport vehicle license. Humbly submitted, this interpretation does not appear to be in tune with the legislative intent. The purpose of the grant of a driving license may not be seen as confined only to the Motor Vehicles Act, but must extend to any other relevant aspect which would be in the advancement of public interest. That interpretation advanced aspect of the matter would be preferred. It submitted that several provisions of the Motor Vehicles Act and the rules which have a bearing on the question of issuance of a requisite license are not brought to the notice of the Honorable Court and so and so. The result in view of the present law laid down in the said judgment, the provisions of the MV Act which are related to the subject of grant of driving license are kept out of reckoning. The key word throwing light on the need for specific and distinct driving licenses to be issued with reference to the specific class of vehicle occurring in Section 3 are effective driving license and the provisions of Section 6 which enjoin against multiple driving license same time. Subsection 3 of Section 6, however, permits the licensing authority to add to the class of vehicle which the driving license authorizes the holder to drive. This can, however, happen only after the due procedure in the MV Act regarding grant of driving license complied with. Consequently, Section 10 will have to be read as to advance the above object. The form referred to in subsection 1 of Section 10 must therefore necessarily include information relating to distinct categories of motor vehicles within the specific class of vehicles. It is therefore evident that every driving license must be a specific reference to a particular category of motor vehicle, and licenses may not be granted generally in respect of class of motor vehicle defined under the Act. Submitted that the intent legislature to categorize the light motor vehicles and transport vehicles into separate classes provided in Section 10(2) of the MV Act. It further provides for a distinct driving license for the class of vehicles as in Section 3 of the MV Act. Therefore, the holder of a light motor vehicle license would not be entitled to drive a transport vehicle of any other category, and this principle would apply to all driving licenses. Therefore, it be reconsidered and suitably modified. So, what I would probably suggest to the court is that since these notifications in question are issued simply in conformity with Article 141 principle, maybe if the notifications stand suitably amended, the rules can be amended, take care of all the situations which Devangan considers. But ultimately, the question whether one driving license is sufficient for driving all categories of vehicles would be a vexed question. You have to very carefully get into it. Somewhere this overlapping seemed to have been missed by the form as well as the Section 10. That's what seemed to have driven us into this problem. So I think Section 3, we talked about effective driving license. Maybe a driving license effective for the purpose of the particular category of vehicle in question.
Yes.
Whole range of illustrations given in Devangan talk about a maxi cab and a light motor vehicle, a car, or a three-wheeler and a similar vehicle. So they don't present any controversy. When you talk about a tractor or a road roller and a light motor vehicle, then there is a problem. Right? Ordinarily, a person who owns a tractor would like to own a tractor driving license, but he doesn't want a road roller driving license. And many of these categories of vehicles are driven in private space, for instance, mining areas, heavy transport vehicles. They are only in mining areas. Therefore, you could have very special driving license for those categories of vehicles.
Yes.
So the union, I think, is advised to withdraw this notification and issue a properly amended set of rules or guidelines, as the case may be.
The Attorney General would also kindly tell us, because broadly in the Motor Vehicles Act, there are the weight categories, right? When you talk about the light motor vehicles, up till a particular weight category, you are looking at certain kinds of vehicles and a holder of a LMB license can drive.
That's right.
Now, examples were given that, a lawyer or somebody with a medical professionals with his equipments, etc., would not be able to sort of drive with a light motor vehicle license if you go into the transport category. And the categorization of transport vehicles into heavy and medium category will also have its implications.
That's true.
So it can't be so, easily said that because you hold a light motor vehicle license, you would not be able to drive a vehicle which is otherwise also carrying goods.
But you're also right, but that will be a process of testing and then granting a license.
But your
Therefore, that
notification
process
has
must go
stood the test of time also. The central government, although you are saying that it's 141 that you have tried to implement, but over the years it has worked itself out. And look at the large number of people, drivers, who are driving commercial
You know,
vehicles.
I certainly alive to that.
So you see, look at the livelihood issue.
That's true.
Look at the, absolving of responsibility. Because if you sort of, I think everybody is taking these aggregate driven cab, etc., riding. Perhaps
No,
most of the drivers are of
You're
holding
right.
LMB license.
I was given all that data. I looked into it, and it's a very, very important
That's a
dimension to be
very,
taken.
you have to
we can't
look
ignore
into the
that.
larger picture there.
Certainly.
The-
But I think, I
the
suppose the
nation has
rules
to be
would be so tuned so that
conscious.
we take care of that also, so that we're not looking backwards. So that is such.
No, certainly,
Yeah.
but these implications, at least in the consideration, not necessarily of the insurance company, but for the country, I think these implications should have a
Absolutely,
consideration.
absolutely.
So then, Mr. Attorney, how do we proceed further?
Since the question, the order talks about the two notification, therefore the Union of India before your lordships.
Otherwise,
Since the
your view is that
notification
Devangan missed critical portions of the statute which were not brought to the attention of the
That's
court.
right.
And that you would therefore withdraw the notifications and perhaps issue fresh rules or regulations as the case may be.
That's right. Which will certainly address
But you will have to ultimately you will have to amend the act if you have to.
No, that contemplation is also there.
You
but-
can't just do it by way of guidelines.
So, suppose section 3, 6, 10 all put together, we look at it and then say, yes, this is how the rules may serve the purpose. But if that cannot be done, well, the act may have to be amended. All that is
To the
also under
government.
contemplation.
The only way forward is if you feel
I-
that Devangan then is to be, either reiterated or overcome.
Legislative.
You have to do it legislatively.
No doubt about that, because when my exchanges of
Existing
thoughts was that,
statutory position is interpreted by the court.
the government
you amend-
simply issued notifications because the judgment has come.
So your
therefore,
point is
I
that you
think we
issued the
need-
notification in
Right.
compliance. It's
That's
not in acceptance, but you are bound to comply with the judgment and
That's
therefore you have complied with it.
But the interpretation given of the legislative intent, that still holds the field.
There could be some gray areas
Holds
where I
the field,
think.
as long as
That's right.
that remains.
Right, but
So-
there is some, but as far as the court's opinion that fresh other endorsement may not be required, maybe slightly on overboard. That statement,
If the existing, now Devangan has held the field for a while, right? That has
Yes,
interpreted the provisions of the law. Now, it's always open to the legislature to Parliament because Devangan is of 2017. It's held the field for 6 years.
that's right.
It is also always open to Parliament to take away the basis of the judgment.
That's open. I mean,
And particularly when the government has implemented it, and why should we withdraw or reconsider the judgment at this stage? And if you are thinking that the judgment is not in line with the statutory position, then if you are willing to amend it as and when you want and change the structure of law.
If the law is
For us to,
why should we answer?
why should
Yeah.
we?
no, that you'll not know that process the thought was already set in motion.
Whenever, so
But the
therefore,
question is today, what should happen to the notifications and all?
Have you said in your note that the government has set in motion the, a change in the law or to review the entire position of law? Because, you know, this is really, this case doesn't raise a constitutional issue, it raises a pure statutory issue.
I understand that, but then the question posed to the AG was only how would you look at the notifications, and then the notification to endorse the view taken in the judgment.
No, what we were wondering was that the government can, in the Ministry of Road Transport and Highways and even otherwise, can take a note of whether this interpretation, the consequence of that interpretation is correct or otherwise. If you feel that no, Devangan is wrong and therefore it has to be overruled, you can make suitable amendments to the law to put the matter beyond doubt.
Yeah, that's
A
all.
simple amendment to say that, well, if you have a
That course
license
will
for this
certainly-
category LMB,
that course of
you
action
cannot,
certainly
you
be
cannot,
followed, yes.
you cannot have, that license cannot apply with respect to a transport vehicle. A simple amendment will resolve
that
it,
will
but
have
then,
the advantage of a prospectivity also. Yeah, or is there another?
I know that course of action certainly open to the government, but
that may then also not, cause hardship to existing compensation claims which have been submitted.
on that I'm
by
very
the
clear.
agency.
It should not have, it should not
Because
any
all
upsetting.
those people who have made compensation
certainly,
claims
certainly.
on the basis of Devangan's
We are very clear on that. I don't think that issue should be reopened at all.
also the
That-
impact
that
on
rests where it
people,
is resting.
on people, on the impact on people. I mean, there may be lakhs of drivers across the country who are today engaged in driving commercial vehicles on the basis of the judgment in Devangan. Now, they will be completely put out of their livelihood, you know. So,
Therefore, the
and
government
therefore,
doesn't
this is
want.
not just, Mr. Attorney, this is not just a question of interpreting law, it's also a question of the social impact of the law. And you may have to balance a road safety on the one hand with the social purpose of the law. And to what extent would the interpretation in Devangan, that is a matter of policy for the government, to what extent would the interpretation in Devangan in that sense cause a serious, you know, impact on the concerns of the government insofar as maintaining road safety? You are developing infrastructure across the country. Will this cause serious hardships in the, you know, in the
Even the law of
actual-
insurance.
So, I mean, we can't decide issues of social policy in the constitution bench. We have to go strictly by law. But we are just wondering whether it would be really in that sense wise to decide the question of law on a question of, on a judgment which has held the field now for 6 years. Parliament, the government and then Parliament can also review what is the actual impact of the implementation of this law.
That's true.
6
I
years
did-
the law
I
has
did
been
think about it.
implemented.
Yes.
The insurance companies have one angle that, look, we should not be made to pay, to take this liability at all. But the government can also take a call on what is the actual impact of the implementation of the law on the ground over the last 6 years. If the consequences are such that it does not pose any grave danger to road safety and protects, you know, the right to livelihood, etc., or you may have some modifications in the future. Give some provision that, well, in the next 5 years or something like that, you must bring your licenses in conformity. You have like a sunset clause. So you may have a variety of options open to you, which we as a court don't have open to us.
True.
There's another.
You have to look at, you know, the rapidly evolving transportation phase. You might have autonomous vehicles coming up. They are likely to come, or they're already being, you know, they are already being experimented upon in other countries. India is not going to fall far behind, isn't it?
Unquestionable.
Today use our own private vehicle, tomorrow morning to just utilize it for transport. So that is permissible today by a person who owns a car without going in and then taking another license for transport, when you can put your own, like in Rapido also. So in such situation where you have permitted usage, flip-flop both of them, in such cases also it becomes very necessary to have, to permit a license, general license, to be utilized for commercial without seamlessly.